Welcome back to Supreme Myths. We are taping this on Tuesday, May 28th. The Supreme Court is going to issue opinions this Thursday and probably twice a week for the next 4 weeks. It is going to be an epic June. I don't mean that in a positive way. I have someone here today to help me talk about all this. Mike Sachs is an old friend of mine back from, HuffPost Live days, which we'll get back to in a minute. Mike went to Georgetown, and while Mike was at Georgetown, I think he had one of the first really important legal blogs and made a name for himself there, and it was very, very smart. He then became Huffington Post's first Supreme Court correspondent, founding host, as I mentioned, of HuffPost Live. He covered Congress for the National Law Journal. He's been on Fox 5 in New York City, and I think a very exciting development. He is now working with Alex Aronson as a senior advisor at Court Accountability. This new organization, Court Accountability, is kind of a spin-off from some stuff Senator Whitehouse has done. It is a nonpartisan research and advocacy organization devoted to fixing the damn Supreme Court and the integrity of our broken judiciary. Mike, thanks so much for being here. That was a long intro, but thanks for being here.
Hey, Eric, thanks for having me.
So to the extent I have some regular listeners on this podcast, which always amazes me, and thank you for those of you who are doing that, you have heard me reference over the years that I always found it stunning. I always mention Judge Posner once a podcast. That in 2013, I was actually talking to Judge Posner privately, and he told me he got an invitation to be on this thing called HuffPost Live with this guy, Mike Sachs. And I said, Mike's great. I know him. I've been on the show. You should go. And when you go, you should tell him about the voting rights case that you wrote, because he had told me privately it was wrong. He thought he came out wrong. And on your show, what did Judge Posner say about the major voting rights case that ended up in the Supreme Court right after the Seventh Circuit? What did he say?
Well, Eric, I should preface this by saying that I did not know you had that behind-the-scenes conversation with him, and did not know that you're coaching to talk about this decision with me. In fact, I was prepping for the interview by reading his new book that in the middle of the night while feeding my then infant son, and saw that he had some bit of a hedging about the Crawford versus Marion County case that established the constitutionality of voter ID, at least as a facial matter. And Posner was part of the lead opinion of that decision that went on up to the Supreme Court, where the Supreme Court, in a 6-3 decision, ultimately affirmed the lower court's ruling. But I saw this, I thought, I wonder if he has doubts about this decision, unbeknownst to me that you would talk behind the scenes with him. And I just found that out today, so thanks, Eric. Yeah. So I asked him point blank, did he get it wrong? And he said yes. And that happened. It was a pretty quick moment in my interview with him. And then people caught up on it. I think Josh Gerstein at Politico wrote it up. Gerstein ultimately was the one who co-wrote the Dobbs leak at Politico story. And then it went out of control there.
It did.
To the point where a whole bunch of outlets started covering this federal judge recants. And then Posner felt it incumbent upon himself to recant the recantation in several articles, I think, in the New Republic or what have you, which caused the back and forth with some other people who had been covering his recantation. So it was, or recanting, whatever the term is. So it was a thing for a few weeks at least.
Well, what he said was the lawyers didn't give him the right facts. And the lawyers then said, yes, we did, and so on. People should know Justice Stevens, while maybe never admitting quite as clearly that he thought the opinion was wrong, he did have second thoughts about it 2-3 years later, which he expressed. Anyway, that whole experience of seeing, so Posner and I had this phone conversation. I'd forgotten some of the details until we had talked this before the show, but we did have that conversation. I was shocked that he would say that to me, because my theme about Posner is he's the smartest, most important person I've ever met who could admit he was wrong in public. Like Scalia would never admit he's wrong in public. I'm not sure Kagan would admit she's wrong in public. She might, but I'm not sure. But Posner admitted it all the time. And that was, to me, that's an incredible thing about the man. Anyway, you and I had a great time about all of that, and it did turn into a thing for you, and it was all good. All right, that was a long time ago. We have a term of the ages, I think. I think this may be the most consequential term, maybe in American history, depending on how the court does various things. We have everything. We have abortion. We have guns. We have Chevron. We have Trump. We have everything. Let's start with what I think might be the most controversial and biggest issue, which is the Trump immunity case. So just by way of a little bit of background, people know the Supreme Court ruled very quickly that he could not be disqualified by states absent action by Congress in the Section 3 litigation. They did that very quickly. That didn't take them very long. The immunity case, how long, Mike?
25 days from argument to decision.
25 days. How long has it been since the D.C. Court of Appeals issued a well-written, long opus on the Trump immunity issue? Months.
That was early February, and it's certainly been more than 25 days since the oral argument that the Supreme Court heard on April.
So they're clearly slow playing this. So I have 2 questions for you. 3 questions, I guess. How you think it's going to come out? How you think it should come out? Those are 2. And then, do you think they're slow playing it intentionally?
All right. Those are each loaded questions. The first question, how do I think it's going to come out? Well, actually, may I go in reverse? Can I talk about the slow playing? So as part of my work with court accountability, we launched a campaign called Justice Can't Wait. And you can find the website, which describes the timeline in which the Supreme Court has chosen to delay at every turn in this whole case and saga since it first arrived at their doorstep in December. And the campaign was based on ensuring and making sure the public understands that the Supreme Court can and should, if not must, issue a decision by May 20th, which has since come and gone 8 days ago from this recording. So both to prove that they know they can answer this question quickly about Trump's immunity from federal criminal prosecution in the same timeline that they decided the Trump versus Anderson Colorado ballot access question, which was a question of really important first impression of a constitutional provision that didn't have to take or could have taken longer to decide if they chose to, but they chose to move quickly with a more prudential decision that didn't really interpret Section 3 properly. And yet, when they want to move quickly, they can. When they know they have to, they can. And then also, May 20th was sort of the outer bounds upon which the court could issue a decision denying Trump's criminal immunity and send the case back down to Judge Chutkan at the Federal District Court of the District of Columbia so that she could proceed with trial and submit the case to the jury and have hopefully a verdict.
Why May 20th? Mike, why May 20th? Sorry, why May 20th?
There have been analyses of trial practice timelines.
Oh, okay.
That a short trial, an 8-week trial, if it began rather like now, would have ended in August or rather in September, and a 12-week trial would have ended like September 30th or October 30th or something like submitted right before Election Day.
Yeah, that's not going. None of that's going to happen. Sadly, go ahead.
All hope is never lost, but yet this is getting to your question about delay. So I just want to recap the timeline and how this got to the court. Trump, in an obvious delay tactic, put in a motion to dismiss before Chutkan that he is immune from all criminal prosecution because he was president when he tried to interfere with and stage a coup, interfere with the 2020 election, stage a coup to keep himself in power despite the popular will. Chutkan said, "Get out of here. That's stupid." In more words than that, and less crass words than that.
Yeah.
She issued an order in early December saying that as much. Trump quickly appeals the D.C. Circuit, but Jack Smith goes straight to the Supreme Court saying, if you want to weigh in, guys, now's your chance. Get this done with so we can get the trial back on track. Chutkan set the trial to start on March 4th. Let's get that going. Let's get this timeline going. And the Supreme Court, they got the petition for cert before judgment in late December and denied cert.
And Mike, let me just say that cert before judgment tool until the last few years was very rarely used, but according to Steve Vladeck, who's the source of these things, and Chris Geidner and others, the Roberts Court has used it a lot. So they could have used that cert before judgment tool, but they chose not to.
Yeah, and the signal then there were no noted dissents. So maybe there was a thought that this is a court that felt the D.C. Circuit's expediting it. Let's go in regular order. Let's see what the D.C. Circuit has to say, and maybe we don't even have to touch this thing.
Right.
That seemed to be perhaps the thinking before going full cynic. Which you and I over the years, I think you a little bit more than I am. I am, but I still have some sense of institutional capacity and consideration, at least for some of the justices, which I've been pretty much disabused of this term.
Good. I'm glad to hear that. Everybody grows up eventually. Go ahead.
Well, it's a case by case thing. You see the big picture, but also you sort of understand each individual justice by what motivates those justices and what motivates them in the broader political environment. So,
by the way, Mike, sorry to interrupt. I'm sorry to interrupt. On that point, I want to plug something. Sorry. Richard Ray at the University of Virginia has written a series of articles about personal precedent, that he thinks we should look at the court not as an institution so much as 9 individual judges and their institutional memories. I just want to tell the audience it's a great series of articles. His name is Richard Ray, R.E. You can find them, and they're really interesting because they have a new perspective on precedent.
Well, go ahead. I think that's right, and in fact, what got me started actually, and this is going to be a very digressive conversation, isn't it?
Yes.
What got me started on all of this was I was a 2L or 3L at Georgetown. And I was thinking about the court. I autodidacted my understanding of the court and its, responsiveness to politics through just going into the library and reading all the biographies and histories of the court and the justices over the years. Stuff I wasn't learning in the purely doctrinal courses, and realizing that it wasn't about the doctrine. It was about the politics and personalities of the people on the court and about power.
Randy Barnett didn't teach you that? Sorry, just kidding.
No.
That was a joke. Sorry, go ahead.
Okay. So I started thinking about the Roberts Court. This is like in 2009, and thinking about how it was forming its docket, thinking about how it got off to a really hard right start when Alito joined in 2006, 2007. But then in like 08, 09, well, actually 08 was Heller. It's like 09, 10, the docket got kind of sleepy. I was trying to figure out why, think about why. Part of it to me was Roberts, and understanding that he has this sense of institutional stewardship and wanting to push the law rightward without tanking the court's institutional credibility and political legitimacy. Looking back to how Hughes ran the New Deal court, for instance. So when Obama came in with the unified political branches in 09, the court sort of pulled back a bit and had to preserve its political institutional capital, saving space for things that they really cared about, like the rehearing of Citizens United in January 2010. I was first in line and camping out to see the Citizens United rehearing in September 2009, which was also Sotomayor's first day on the bench for oral argument. And from that experience came a thought that maybe I could do this more. So when I had a semester, my winter, spring 2010, where I had no morning classes Monday through Wednesday, and live a 5-minute walk from the Supreme Court, I thought, hey, maybe this is where I can start putting out into the mainstream, into the public, and to court watcher community, my theories about this court as being responsive to politics, and doing so by talking to the people who wait outside and camp outside the Supreme Court, feel strongly enough about the cases to do so. And then come for that stunt where I'm sleeping out in the middle of winter, in the middle of the night in front of the court, and stay for my analyses of the cases the court was hearing that term, and my impressions of the court's docket formation and manipulation of public perception.
Wait, hold on. Manipulation of public perception is a great phrase for what the Supreme Court does. Thank you. Go ahead.
And we're going to see a lot of that. We're seeing that this term. This term is all about that, by the way. Okay. We'll get to that.
Yeah.
So this was my theory and thesis going back to, I guess, when I first really started paying attention to the court, and it's borne out. It's proven correct and proper. There's been adjustments here and there based on how the political environment has changed, and based on how each justice has responded to his or her role in those moments and in that broader environment, whether they care or not, to the extent they care, what cases and issues trigger their caring, etc. So let's bring that back to right now.
Yeah. So how does that? Right. So that, by the way, that I should also mention to people, because you were talking about your personal development here. I did send you, I believe I sent you a draft of my book or the final book. I don't remember. And you were very supportive. I remember thinking, no one in those days said, yes, Siegel, you're right, the court's not a court. No one said that. But you were 99% supportive or 98% supportive. And that meant a lot to me at the time.
Well, it meant a lot to me that you shared that with me. And, I have a slight dissent from your court is not a court, in that I think the court's always been, law has always been this way.
We'll get to that. Let's not digress to that right now. This term, going back to Trump.
Let's get back to the Trump immunity case. So the Trump immunity case, the justices may have, if you're not being so cynical about it, may have sent the case back to the D.C. Circuit because the D.C. Circuit was moving quickly enough.
Yeah.
And the DC Circuit heard expedited oral arguments, and they came out a few weeks later, early February, 3-0, bipartisan, with 2 Biden appointees and probably the most maybe the most conservative, still active judge on the court, a George H.W. Bush appointee named Judge Henderson. And that was a 3-0 decision, just rejecting Trump's immunity. Again, like what Chutkan said, get out of here. That's a stupid It's a stupid argument. And they knew it was a delay tactic. Everyone knew it was a delay tactic. Trump's lawyers knew it was a delay tactic. Everyone knew. And the tell for the DC Circuit on why they knew it was a delay tactic is that they gave Trump a week to run, not walk, but run to the court to file cert before they sent the mandate back down to the district court to get the trial going.
Right.
So Trump ran, didn't walk to the court, and Smith, a day later, he was given a week by the Chief Justice to respond. Jack Smith, a day later, wrote his reply. And then the court sat on it for 2.5 weeks before then granting cert at the end of February and putting the argument for not the last day of oral argument, but the day after the last day of oral argument for this term on April 25th. It was a Thursday. So
it's infuriating. Sorry, go ahead.
Those pieces all made it seem as though this court was seeking delay for delay's sake.
Yeah.
So that by the time they answered the question presented, it would be too late for the trial to conclude before Election Day, and thus running interference for Trump, because a majority of Americans and voters do want to have that answer to inform their decision on how they're going to vote on Election Day.
And I do want to say that the court has a long history of acting quickly in absolutely landmark cases. The
Nixon tape case, Bush versus Gore, Trump versus Colorado, the steel seizure cases. You're going to say yes, all of those things.
Yeah.
But in this case, they are not. And the conventional wisdom, which I adhered to at the time, was before the oral argument, was that it wasn't what the court was going to decide. Of course, they're going to say Trump's not immune. This is ridiculous.
Right.
Maybe there's Thomas and Alito, maybe Gorsuch, but come on.
Yeah.
They're not going to say Trump's immune. It's too frivolous, patently frivolous of an argument. It was a matter of when they're going to decide, whether they're going to drag their feet, whether they're going to rule on May 20th, or whether they're going to wait till the end of the term or somewhere in between. Then the oral arguments came, and you could count 5 justices who were looking to delay the case for various reasons, but ultimately with the mechanism likely to punt the case back down to the lower courts to figure out whether Trump's acts were personal acts or official acts. Because Trump's argument, if you remember, is official acts get immunity, personal acts do not.
They admitted that. I want the audience to understand. Yeah. Trump's lawyer admitted over and over again that if he was doing something completely personally, the problem is his definition of that was almost microscopic.
Exactly. And the lower courts all gave a categorical rejection of that kind of immunity.
Right.
And as at least narrowly as applied to Trump's acts. They said they didn't have to get into the broader stuff.
So, Mike, I have a question about the argument for you.
Let me just, but then Chief Justice Roberts, he seemed most interested in rejecting the lower court's blanket rejection, the categorical rejection of the concept, at least when considering Trump's acts, of this official and personal distinction. And that was, I think, to a lot of court listeners, especially to me, dispositive how the thing's going to come out. There were 5 votes for that. So the fix seemed to be in, and the court was very much divided on this. The unity that you might have seen, or the unity that was presented with dissenting voices brushed under the rug in the prior orders for the cert and the cert denial and the cert grant, that was gone. The fracture was very well apparent. And now we're in a position where, yes, I think it is very clear to impute upon this court, to infer upon it from its decisions, or from its actions so far.
So
that they're seeking to delay to help to at least aid the Republican candidate for president in 2020.
There was some reporting last couple of days that Justice Sotomayor is mad and upset, and Kagan is mad and upset, and all this stuff, and that doesn't give me the warm and fuzzies about what's to come. The thing about the oral argument that stood out to me above all else. Now, again, this comes from my perspective as a court critic. It's what I am. But a lot of my non-lawyer friends who read about this were really confused about it. Now, again, my non-lawyer friends are not Trump supporters, so I didn't talk to Trump supporters about this. But, Mike, they were so upset that every single time a government lawyer tried to argue the facts, the court cut them off, refused to let them do it. And the reason I ask you this is because so I have a colleague named Neil Kinkoff, who is actually a separation of powers expert. He's on a separation of powers casebook with some very big people. I know a lot about separation of powers. It's not my wheelhouse, but I know a lot about it. And it would have been so easy for the court just to say, we're not going to answer the question in this case, because it is a difficult question about immunity. It's not as easy as it sounds. And I think there are some ripples that get complicated. But this case is not, because first of all, a president cannot be responsible for his own election. That's like a judge being the judge of his own case. So Trump's argument that he had a role to play in the Electoral College is just obviously wrong by everybody. No one thinks that's right. He has no role to play in the Electoral College. Why? So the double whammy of the court not allowing the facts to be said out loud, plus the delay, makes me think this is really bad. But Mike, I think a lot of things are really bad, and a lot of people think not so much. But this sounds really bad. Is this really bad?
Yeah, it's really bad. Okay. And what was astonishing, what you're saying is true, that you had Gorsuch and Kavanaugh and Alito saying, we're not worried about right now. We're worried about the future.
Right.
But like the problem was right now, like the facts before them were well beyond the hypothetical bad actor that could happen in the future. They're thinking about assassinations of political rivals and vengeful prosecutions of it. But dude, like we have a president seeking to keep himself in office by subverting the Electoral College and inspiring an insurrection to get in the way of its count. Like that's the stuff of hypo is past. Like if this case were to come before the justices 10 years ago, like those would be the questions that justices would be asking for future hypothetical bad actor.
Yeah,
there's a lot of commentary on the people defending what the court's doing. I've seen saying, well, the question presented is very broad. Sure, they've never had a problem answering questions presented more narrowly. The question presented that they formulated came out was the average pretty much of what both Trump and Jack Smith had asked. They both also came forward with pretty broad questions presented, but Jack Smith also presented his argument in his briefs in a way to say this might be a broad question, but like you don't have to go the whole way. You can answer specific to these particular facts.
Yeah, it's really
it's bad. And I think should the court come down with a punt on this case, which I think is very likely, saying okay, there is some zone of presidential immunity, lower courts figure it out. That's going to be their attempt to say, look, see, we're not siding with Trump. We're not saying he's immune. Right. So don't hate us. But I think a lot of the country is going to see through that and it's going to further take the fig leaf, whatever remains of legitimacy, off the court's privates.
Okay. We're going to get to abortion and guns in a second, but one minor digression. You said the question presented was very broad, but the court could have decided it, more. Now I agree with all of that. I haven't had a chance to mention this yet, I don't think, on my podcast, or maybe I mentioned it once. I want everybody to remember one Twilight Zone-esque thing that we never talk about, which is the federal statutes that give the Supreme Court the authority to hear cases from lower courts require them to hear the case, not an issue. And this whole idea of the court limiting the resolution of a case to questions presented is actually in complete inconsistency with that federal statute. It is the last federal statute on the books about this. They've been acting lawlessly for a very long time. A Federalist Society law professor at Penn State has written a lot about this, and he's right that there's no such thing as question presented. The court promised the Congress they would take the whole case, and whatever has to be resolved could be anyway. Just a little aside. All right. So we have Trump immunity. It's going to be disastrous. I don't see, even if they come out and say he doesn't have immunity, if that's on June 30th, it doesn't really do it doesn't really help us in this moment of need. So it's just terrible. All right. We have two gun cases. There's one involving a congressional ban on bump stocks. I don't want to talk about that one. We don't have time.
But Eric, should we talk about the January 6th defendants case as well?
Yeah, maybe at the end. I may let us end with that one. I want to talk about guns for a second because Because you're really a sophisticated court watcher. What I mean by that is you're not like me. You're not just a critic, but you are critical enough where you see through. You've always seen through things a lot of other court commentators have not. So what happened in 2022 with the Bruen case was the court invalidated a New York law from 1911 on the grounds there wasn't a long enough tradition of having that kind of law, which is kind of insane since it was 1911 law. And Texas had one in 1860, same law. But leaving all that aside, this case rejected, as everyone knows, any kind of balancing of the public interest against the right, and instead said he could only uphold gun laws that have a long history and that were present at the founding or in 1868, or laws that are very analogous, whatever that means, to current law. And that drove lower court judges crazy. Carlton Reeves, among others, wrote long opinions saying, we can't do this, we're not historians, blah, blah, blah. The court has a chance to correct this in a case that you would think they will reverse from the Fifth Circuit, involving a guy who had threatened his girlfriend many times and was under a protective order, and therefore, under federal law, could not own a gun. And the Fifth Circuit invalidated that part of that federal law, saying it's unconstitutional because there were no LUNs disarming these kinds of people, meaning people under domestic relations protective orders back in the founding in 1868. So my two questions to you are, how is this case going to come out? And for the love of God, are they going to walk back Bruen a little bit?
This case is going to come out for the government.
Okay, good.
But the question is how they're going to do this cleanup on Isle originalism.
Yeah.
Because Bruen made a whole mess of everything.
Did. I've called it insanity.
Yeah. And, you know, speaking of Posner, didn't he author the first case out of the gates post Heller expanding the right to keep and bear arms beyond the home? I believe. Okay. For the audience, Mike just brought up Posner, not me. So,
Bruen.
Wait,
hold on, Mike. I want to mention
ratified that.
Posner criticized Heller when it came out. He said it was terrible and awful. But then, as a lower court judge bound by his superiors, he followed it and invalidated an Illinois gun law. That's another thing Posner did that the Fifth Circuit could learn from. Follow Supreme Court precedent.
This wasn't a gotcha moment. This is Bruen ratified that bottom line that the individual right to keep and bear arms for self-defense goes beyond the home.
Yes.
Which is what Heller did.
Yes.
And then McDonald extended to the states.
Yes.
But what the Seventh Circuit did, and I believe what other courts following on did, whether or not they agreed with that bottom line, is they established a means-end test for how to figure out what to do with Second Amendment claims. And the Supreme Court sat out of this entire debate for a decade, more than a decade. Tried to get it a decade later, but New York mooted the case before the court could take it up.
By the way, Jake Charles and I both agree. Jake is a leading Second Amendment guy. They did that because they didn't know how Kennedy would vote. The conservatives,
exactly. Yeah. And as soon as Kavanaugh joined the court, they granted this case out of New York, not Bruen, but its predecessor. And New York moved quickly to moot the case over the anger of the right wing of the court. So then Bruen comes up, and to reach the same bottom line that courts like the Seventh Circuit had reached. Oh, and by the way, Posner did not actually have to reach that decision because they could have just limited Heller to the facts for right to keep and bear arms inside.
Hold on, no, I can't, Mike. I can't, Mike. I got to tell you something. So that's true. What you just said is true. There were an infinite number of ways Posner could have gone the other way. He and I talked about this because I was shocked that he did it. And after the fact, he told me his best reading of what he was bound by was what he went by. And he didn't like it, but he felt bound by it. So I don't.
Sure.
Okay, go ahead. Sorry. I got defensive there for a second.
What Bruen did, though, was throw out all that lower court development in the law.
Yes.
A lot of good ideas for how lower court could develop a law. Sort of like how the lower court in the Trump immunity case figured out the law. Sort of like how the lower courts in the partisan gerrymandering cases were able to figure out justiciability of.
It's a theme.
And this court was like, nah, but we're gonna do it how we want to do it in a way that is the most smashiest, grabbiest way towards American democracy and the will of the people.
Right.
So they had this whole thing about if at founding or at Reconstruction, we're not going to decide which one because it's not in our best interest to do so right now. We're just going to be hacks and say either way. There were no such prohibitions or history and tradition of such prohibitions on public carry or whatever it was that So we're just gonna strike down this 1911 law because it came too late after 1868, but certainly too late after 1791 to give us an understanding of what's going on.
Although there was a Texas law in the 1860s or 70s that was the same, but go ahead.
Yeah, but they're cherry picking. Yeah. It's originalism is dumb. Yeah. And it's just meant to justify results orientation.
My man.
To project one true way. Okay, so post Bruin, I think the court was looking to call into question like assault weapons bans, sensitive place laws, magazine limits, 18 to 20-year-old bans, but I don't think they were looking to call into question federal criminal laws with different prohibitions on felons, on people under domestic protection.
You would hope
orders, or like drug users. Now, these things, I don't think the court meant to crack that egg. They weren't thinking that far. And lo and behold, all these cases start coming forward. And one of them is this case out of the Fifth Circuit, the Rahimi case, with the YOLO Fifth Circuit, the MAGA Fifth Circuit, taking the reasoning of Bruin the same way that, say, Posner took the reasoning of Heller to its logical conclusion, if not extreme. And you know what? They were right. They were following the logic of Bruin to where it should go. There was no history and tradition of disarming people under domestic or the protective order for domestic violence, perhaps because there was no protective orders for domestic violence.
Because men could men could beat their wives in 1797.
Exactly. And so I think what this court's going to have to try to do, and they're probably hard at work trying to figure it out, if not now parrying dissents and majorities back and forth at this moment, is how to save face. Not to say Bruin was wrong, in fact, to say Bruin was right, but it didn't encompass this because there's a dangerousness element that we have to consider. I think that was the thing that Barrett latched onto an oral argument, is a consideration of dangerousness that can animate federal law's validity under the Second Amendment.
Although she did dissent in a Seventh Circuit case that applied the Second Amendment. I mean, that said felons could be not the same fact.
But you know why? Because those are non-violent felons. Yeah. And this gets back to cases coming out of the Third Circuit. And there's actually a circuit split on this, on whether or not people with non-violent felonies can be disarmed. And the other wrinkle with that Barrett Seventh Circuit dissent was that she said that people can be stripped of their voting rights for nonviolent felonies, but they can't be stripped of their gun rights.
I hated that dissent. I hated it so much.
Which was ridiculous. But that's something to watch also. When you have those two things, it's anti-democratic.
When I read that dissent, I think I wrote a blog post about it, but I don't remember. When I read that dissent, my first reaction was, there are no democracies where there's not free voting. I mean, no, we all have different degrees of voting, but I mean, where there's a norm of we hope people get to vote in a plainly transparent and democratic way. There are trillions of not trillions. There are hundreds, I think, of democracies where they don't have gun rights. So to equate the two is just incredibly stupid. All right, I want to ask you a big question about Bruin and this Rahimi case.
Yeah.
So little philosophy halfway through the podcast. Little philosophy. In 1993. When you were a babe, Professor Mark.
I was 11.
You were 11. All right, shut up. Professor Mark, I was not. I was teaching law school. Professor Mark Tushnet was a mentor of mine. And he had time he was at Georgetown, went to Harvard, famous radical, famous leftist, became more moderate as the years went on. Mark told me in 1993 that he had a test. And it worked almost every time. Not every time, but enough times where it was a good test. Can you close your eyes and imagine a New York Times headline? If you can't imagine the New York Times headline, the Supreme Court is probably not going to do it. So in 1993, right after Casey, we talked about Roe. Can you imagine Roe reversed by Supreme Court? And we both said after Casey, no, it's really going to be hard to. I said it's going to happen someday, but we're decades away from that. That test. Can you imagine the New York Times headline? So to me, in thinking about Rahimi and what I've said publicly, so can you imagine a New York Times headline? Supreme Court upholds Fifth Circuit decision invalidating federal ban on domestic abusers owning guns, however the Times is going to paint that. And no, I can't imagine that headline. I'm assuming you can't imagine that headline, but that's not my question. My question is Tushnet's test still a good one? And I don't think it is. It was for most of my life, but it's not anymore.
You have a majority that does not care about the New York Times.
Well, it wasn't even caring about the Times. Just Is it?
Well, no, I mean, they're not afraid. They're not afraid of headlines. They're not afraid of bad headlines because they exist in their own bubble. Now you can say maybe Roberts is slightly outside of that bubble, ever since he proved himself a heretic in the Obamacare decision in 2012. But still, there's very much about the company they keep. There's I forget, Bauman and Devins, I believe, political scientists who wrote a few years ago.
I went to law school. Neil Devins and I were friends in law school. We went together.
And in the run-up of the Dobbs decision, you kept seeing people, there's no way they're going to do this. Thinking about the outcry. I'm thinking, no, they'll be hailed as victors and as heroes among the company they keep for finally offing Roe in ways that earlier iterations of Republican courts could not due to bad vetting. So that was totally imaginable, the Dobbs decision. But no, for the Fifth Circuit stuff, absolutely not. And I'll tell you why. The Fifth Circuit is pushing the law as far as it can go, because those judges are not only true believers in their ideology, but also now true believers in the fusion of Trumpist Republican politics with judicial politics.
That takes my breath away. That sentence literally takes my breath away.
Well, but it's obvious. So the story of this term and the headlines that I think the court's power center of Roberts, Barrett, and Kavanaugh, they won't stick together in every case, but the overall aggregate of that power center, the narrative is that they want to achieve, but it won't be true, but they want to achieve, is the Supreme Court moderates, or this is a Supreme Court, this is not an extreme Supreme Court, because they'll be defining themselves in comparison to, in contrast to the Fifth Circuit. The big cases this term are going to be a lot of cleanup on Isle originalism and slapping back the Fifth Circuit's extreme.
So speaking, and we've got to move on. Speaking of the Fifth Circuit, we have Trump immunity, we have 2 huge gun cases, and we have 2 huge abortion cases.
Well, I want to actually expand on this, because in each of those cases, well, immunity not so much, or the Trump cases not so much, but the gun and abortion cases, this court's going to be looking to have split decisions on the cases within those issue areas. They formed their docket specifically to achieve these split decisions.
I'm going to quote you, Mike. I'm going to quote. That's going on Twitter. That sentence right there, because I've been talking about the court's docket ability to keep its own docket forever, and no one seems to care. Go ahead.
And there's some cases where they have no choice but to take a case, right? Whether there's a circuit split or whether there's a lower court that strikes down a federal law or what have you. But you can see very much a pattern here in, win and loss, having like 1 and 1 in each column. But even in the loss for the conservative, for the right wing side, I'm also reluctant to even call this a conservative court, because it's not. It's right wing, but there's not much conservative about the smashing and grabbing going on in this counter-revolutionary moment.
Yeah.
So it's reactionary, right wing. There are some conservative moments where you'll see them, but overall, it's not. But what you're seeing is using the Fifth Circuit as a foil, and having cases that say that the CFPB case, where the court just refused to blow up the CFPB, and the SEC Jarkizi case, which I think they will hold off on blowing up the SEC, even though they will cut away at its efficiency of deciding securities issues. They're gunning for, no pun intended, since we're still ostensibly on the gun section here of this discussion. They're gunning for headlines that say the court is moderated. Remember, the past couple terms have been insane. They've been wildly disruptive to the law as we knew it. Of course, the law as we knew it was an exercise of power from previous.
But Mike, only on abortion, affirmative action, guns, separation of powers, federalism, and everything else.
And down the line, every single one of those issues this term, has been designed to present a vision of offsetting radicalism. So sure, they didn't blow up the CFPB, but they're nuking Chevron, which is going to be far more consequential. Than I don't know. I guess nuking CFPB would be pretty consequential too. But either way, more pervasive would be is getting rid of Chevron, because that further aggrandizes and collects power in the judiciary, to be the veto point, the de facto deregulator.
Yeah.
The one-way ratchet of federal regulation.
A non-con law professor.
On behalf of the Republican Party and corporate interests that back it.
A non-con law professor who's very brilliant wrote a New York Times op-ed. He's not a con law guy, saying anybody with eyes can see that what the Roberts Court is doing is giving itself power. He called it the imperial judiciary. And it's so ironic to me, Mike, because, again, I'm 65, so I'm much older than you. And I have such vivid memories of working for the Bush Justice Department in the late 1980s with mostly conservatives, not all, but mostly. And, they were so sincerely, I think, upset about the war in court. That was still the lingering law. And they were so sanctimonious about judges acting out. And all the Roberts Court is doing is the war in court, maybe even on steroids. I mean, at least it's the same. It's the same amount of aggrandizement.
The distinction is more or less that the Roberts Court, that the Warren Court, its activism was to vindicate democracy and democratic values. The criminal procedure stuff, maybe not so much, but that was then was deeply racially tinged, and they were trying to break the back of Southern apartheid and general American racism and constitutional law. And
now Clarence Thomas wants to reverse one person, one vote. He does.
Yeah. But the Roberts Court's activism and the current right wing activism that we saw really transform during the Obama administration, particularly.
Yeah. So Mike, you are running out of time, so I want to get to these abortion cases. Sorry, we could talk for 10 hours on this stuff.
That'd be bad. We can have a sequel and get to the rest.
Really, we can do that. The abortion cases, because they fit into your theme. Again, there are two gun cases. I agree with Mike. I think one's going to come out for the government, one probably against the government. We have two abortion cases, one involving abortion medication, which is the way most women get abortions in America today, and one involving emergency rooms that receive federal. I want to be very clear about the second case. Emergency rooms that receive federal funding, and only because they receive federal funding, they have to follow certain federal rules, including if a woman presents in an emergency situation, you save the woman's life, period. Yeah. And if you have to lose the fetus, you lose the fetus. And some states don't want to do that. And so there's a spending power case, and then there's the FDA case involving its imprimatur on, I'm not going to pronounce the drug, but the various abortion drugs. What's going to happen with these cases, and how are they going to happen?
Okay, in the abortion pill case, the court's going to have a lopsided ruling saying that the Alliance for Hippocratic Medicine, which is a made-up organization that was formed by far right-wing legal advocacy groups, to be situated right near Judge Matthew Kaczmarek's courtroom in Amarillo, Texas, knowing that he would do what they wanted. The court's going to find that those plaintiffs did not have standing.
Okay,
but, and that's going to be the one thing. That's going to be like, see, Fifth Circuit. And Emperor Amarillo Kaczmarek, you guys, you're ridiculous. Get out of here. Look how moderate we are. We overturned Roe, but see, we're still going to let abortions proceed in America.
Yes.
But what that case will ultimately do, though, well, it might further tighten standing laws, but probably not, because they still want right-wing plaintiffs to get through. Is they're going to leave open the possibility for states to have standing. And Kaczmarek already greenlit Texas's standing to intervene in this very litigation that could come right back up to this court in a year.
Yeah.
But if Trump wins, we'll have worse things to worry about. We'll have like the curtain coming down in American democracy. But if Trump wins, his HHS at least the HHS in waiting has already said in this Project 2025 white paper that the Heritage Foundation came out with Roger Severino, who'd likely be the presumptive HHS administrator. They've said that what they want to do is revoke the FDA approval of the abortion pill. That's a question here. But also reanimate the Comstock Acts of 1873 that makes illegal and criminalizes any mailing through the interstate mails of any literature or device that aids abortions. Now, this has long been in desuetude. It's
it's unconstitutional as applied to literature. We know that.
Well, yeah, but for the tools, for the instruments, the courts and the federal government have long read this statute not to apply to abortion. Even by its plain language, it does. So you'll either have courts under a next Biden administration seeking to, through Texas' standing, seeking to reanimate Comstock and further make and further cut away at abortion rights, despite what Dobbs said about it being a state thing, or you will have a Trump administration doing the bidding that through administrative law that the Supreme Court will refuse to do this term.
Mike,
and then you have the EMTALA case outlined.
Hold on, before I get to the emergency room case, because I do want to give a brief background to that, my own ideology. But on the abortion pill case, I want people to understand. I disclosed this before. I met my wife giving a talk to Planned Parenthood. She was the board chair of Planned Parenthood here in Atlanta for a few years. I regularly contribute, and talk to Planned Parenthood. So I have that bias. I have pro-choice bias. Although I always thought, as you know, Casey and Roe were incorrectly decided. This abortion pill thing is huge. If, in fact, at some point in the next few years, a court, I agree with you about this case, but if a court does find standing and does require the FDA to go back and do different things, there's going to be an incredible amount of pain and suffering among women who feel the need to have an abortion. And it is a horrible thing for the court to wade into. I think it violates separation of powers. And it's something that is, I just want the audience to understand how serious this is. Do you agree with that?
And also, don't forget, the judges on the Fifth Circuit, Judge Kaczmarek in the district court in Amarillo, they're next.
Yeah.
They're the next justices, not just under Trump, but under any generic Republican, because every generic Republican today, judicially, is fully on board with this judicial supremacy coming out of the right wing to engineer against the people's will an anti-democratic policy making and breaking apparatus centered in the courts. That's that. So, whether it's Sotomayor, or whether it's Roberts, whether it's Kagan, or whether it's Alito, like the next group of Supreme Court justices coming up from Republican presidents and Republican senates will be the Fifth Circuit judges, and those like that.
Well, across the country. But you say that, and you're right. And
let me just take one more step on abortion. You're talking about the whole judicial restraint thing. That was an article of faith among the conservative legal movement when you were coming up.
Yeah.
And that was, there was Warren Court, but then it's supercharged with Roe. That was liberal judicial activism was code words for Roe versus Wade and upholding Roe.
And Miranda and Roe.
Sure.
Miranda.
Sure. Yeah. But post 2000, when Rehnquist buried the Miranda, it became fully.
Yes.
So there's something I call the reverse Roe, which is constitutionalizing the anti-abortion position, which is using the 14th Amendment to declare fetal personhood under the 14th Amendment's guarantee of life, and then knocking down every abortion permissive law.
It's not going to happen in the country. That's not going to happen.
No. But what I'm saying is the next round of judges who are coming up, they're for that. They're for that.
I know.
So probably one or two on the current court that are as well.
So the Dems have to keep the Senate. That's the answer to that question. The Dems have to keep the Senate and not confirm Judge Ho or not confirm Judge Justin Walker, the idiot on the D.C. Circuit, or whatever. They have to keep the Senate. That's the only way.
And all I'm saying though is the next wave of the wave of justices that we have now are the no more suitors generation. They were there to knock out Roe versus Wade. They're knock out affirmative action. They're knock out campaign finance laws and strengthen the death penalty, clearing the slate of all the stuff that's been bedeviling us since the 1960s and 70s or 70s.
You're right.
The Burger.
No, you're right.
Right.
You're right.
But then Vanguard coming up, the ones that came up through the Obamacare cases and the contraception cases, which were also Obamacare cases, and the ones that came up when the right turned against Chevron. That's.
I know.
Those are the ones that are going to look to ban abortion under the 14th Amendment nationwide.
Okay, that was a depressing moment. So let's move on. Because you're right. We could very easily, if Trump wins, we could easily see Judge Ho and his ilk replacing whoever retires, and that would just be a disaster. All right. I do want to talk about the other abortion case, but I want to talk about it, Mike, both the stakes in that case, but I want to talk about it broader. Because I think people listening to this podcast, I want to give them an on-the-ground example of Supreme Court awfulness that I think they will understand. Maybe they won't, but I think they will. And then we'll use this case to do that. So the issue in that, well, you lay out the issue, and then I'll give the background. What is the exact issue in the second abortion case?
I mean, you already described it well, but Idaho has a flat-out ban that pretty much only has an exception for when a woman's on death's door.
Right.
When she can get an abortion.
Right. And the federal rules say be more sensitive to the woman's physical and fatal needs. Okay.
Yeah, the federal law governing federally funded hospitals and emergency rooms is that if a pregnant woman comes in and needs an abortion to stabilize her condition.
Okay. So
federal law permits that. So this has a case where the daylight in these instances of emergency medicine between Idaho's death's door exception and the federal requirement for treating someone for giving someone stabilizing treatment.
Yeah.
That may include an abortion.
Okay. Now I want to be clear with the audience.
Yes.
Idaho can do whatever it wants, as can all 50 states. If whatever emergency room rules they want to put on their own state hospitals, they can do that. The federal government there's no law saying that I know of that federal emergency rooms must do X when it comes to abortion. What the law says is, if you want our money for your hospital, then as a condition of accepting our money, you have to agree to do X.
Yeah.
Those are very different things, and they come from different parts of the Constitution. Parts of the Constitution gives Congress the power to regulate, prohibit, alter, destroy on its own. The Commerce Clause is the normal source of power for that, but there's some other sources of power. That's not this. This is Congress has the power to spend money for the general welfare. And after 1936, the court gave Congress basically a free hand in the spending power. Even Justice Rehnquist, who I think to this day is the most states' rights justice of my lifetime, sincerely states' rights in most situations, as sincere as a justice can be. Even he took a broad view of the spending power. Everybody thought the court would make the spending power harder to exercise during the 1990s, when the court made sovereign immunity bigger, when the court made anti-commandeering bigger, but it didn't. It never did that. It never dropped the spending power shoe. The Roberts Court comes around in NFIB, where every state signs a contract every year saying to the federal government, we'll abide by your conditions, and in return we take this money. And everybody knows the Obamacare story. They had 4 years to prepare, 2 more years where the federal government was going to pay for it. And the court strikes down, for the first time since the New Deal, a spending power law saying the law was retroactive. It was not retroactive in any way, shape, or form. And the states were not on fair notice. They absolutely were. And the fact that Kagan and Breyer joined means nothing because they were coerced, blah, blah, blah. Now we have
coercion. So, can I interrupt you really quickly?
Yeah.
All the people who hated Roberts for that vote, for switching a vote on the mandate, ignored the fact that he pushed the law so hard to the right in doing so.
Yes.
He still gutted the Commerce Clause as an instrument of broad national power.
Yes.
And then also, on the bottom line, gave states a free hand to opt, well, they already were free to opt out. They would just lose all their Medicaid funding. Yes. But that, if you wanted to cripple Obamacare's broad reach, as a bottom line political matter, Roberts is commanding a 7-2 majority to let states opt out without losing their Medicaid funding of the Medicaid expansion was a massive win for the anti-Obamacare position.
Yes, and I want to be clear, it was
doing so. He also supercharged the coercion element of the spending clause jurisprudence, and yet he became a pariah among his movement because they were so obsessed with this one individual mandate that ended up not being that big of a deal. So Roberts, all along, going back to this sort of what do individual justices care about, he's been trying to save the Republican Party from itself through the political waves and roller coasters have been happening since he joined the court.
That's a great.
He's been saying, if you just trust me, you guys will be okay. And the majority he has with him now is saying, we don't need you anymore. We're going to go for it. And it seems as though he, for a little bit on some cases, especially the Trump immunity case, it has, when he doesn't have the power center, has capitulated that and he's going to ride that wave.
So going back to the emergency room case and to NFIB, the court held that there was so much money at stake the states couldn't say no, therefore it was unconstitutionally coercive, and that was all stupid nonsense. Every state could say no. There was nothing stopping them from saying no. It was not your wallet or your life situation, because the federal government could end all Medicaid, Medicare tomorrow. Tomorrow could end it and say, states, you're on your own. So this case, though, this case is so powerfully important for both American women who need to live, first and foremost. And second, it's a spending power case. Do we really think they're going to, I mean, again, this whole coercion idea is nonsensical. States have the right to say no. If someone,
but you can shout that as much as you want on your Supreme Myths podcast, Professor Eric Siegel.
Yes.
But this court doesn't care. But what this court does care about is maintaining some semblance of where it matters, where there's some play in the joints, where there's some softness, where the core component of their jurisprudence is not at stake. Some idea of moderation so they can build capital for when they want to take the huge swings.
But
and so with the EMTALA case, what you heard, the way that they could have gotten around the spending issue is that they could have said, and Idaho presented this, that EMTALA, the federal law, does not actually, abortions are not medical care.
Right.
Like that. But the court did not seem to be.
Well, really abortion is medical care, so I'm glad they didn't say that.
Right. But the court didn't seem to be getting behind that. What you saw instead were Barrett and Kavanaugh, who've become actually kind of a duo this term. You'll be seeing like they've been sending wink, wink, nod, nods down to their compatriots in the courts below to slow their roll so that they can legitimate themselves. In this case, they seem to join in an argument with this idea that maybe EMTALA and the federal and the Idaho ban aren't incompatible, and saying that the commands that EMTALA makes on emergency room doctors for stabilizing care is consistent with the Idaho law's exception.
Yeah, Mike, let me tell you that in Georgia, we had a similar situation years ago where they passed a law that made it unclear what the doctor's obligation was in that crucial few moments of, is this woman going to survive this birth and all that stuff. And they thought they did it pretty clearly, and the doctors were like, you cannot do this ahead of time. You don't understand. There are too many variables, we're always going to try to save the woman's life. Like that's how we roll. That's what we're going to do. And this law did not give us any guidance, and argued it was vague, unconstitutionally vague, and the law went away eventually. So I don't think there is space. I mean, I really don't.
Well, I think the facts bear out that there is when you talk about women who are getting airlifted out of Idaho's borders to get the care they can't get in Idaho, because Idaho is fighting the federal law at issue. But I think you're going to have Barrett and Kavanaugh, maybe Roberts, running with some opinion, whether it's a commanding plurality or they get the liberals, I don't know, to wink, wink, nod, nod to Idaho officials and Idaho and the courts below, to say, no, actually, these things are coextensive, and emergency room doctors in federally funded hospitals in Idaho can comply with EMTALA without getting arrested under the Idaho ban. That's what I think is going to happen. But they're not going to side against Idaho. They're going to maintain Idaho's. They're going to say Idaho's abortion ban is still kosher.
Mike, one last doctrinal question about
or suggest it doesn't. Send it back to figure that out.
Yeah, I have a. This is kind of a nerdy moment for the audience, so I'm sorry. I apologize for the con law nerdy moment here.
I mean, this whole podcast has been that area.
No. Listen, I have a question. If Congress, we did not talk about this beforehand. This is going to throw you for a loop, probably. Or maybe you've thought about it. I don't know.
Cold call me, dude. Let's see.
If Congress can do something via the Commerce Clause, if it were constitutional, were Congress able to do it via the Commerce Clause? And I think via the Commerce Clause, Congress could tell ERs that work, even nonprofit ERs, what they can and cannot do as a regulatory matter, not a spending power matter, because the commerce that goes into emergency rooms is all out of state. I mean, we have 1,000 reasons we can do that. If it's legal under the Commerce Clause, by definition, shouldn't it be legal under the spending power?
I don't know.
You don't know? Is that what you said?
I'm not going to answer that. Good. Because there are all different ways it could go. They could find some way to say
not them. You don't you think if Congress can prohibit something, it can therefore pay the states to do it or not?
I mean, I believe in a broad construction of federal power under the Reconstruction Amendments, and think City of Bern versus Flores should be overturned.
Me too. Yeah.
And we should abide by both the the McCulloch versus Maryland Hamiltonian view of broad federal power, as well as the radical Republican Reconstruction Congress's view of federal power. And the Wickard v. Filburn New Deal courts broad construction of federal power. So whatever clause you want to use, whether it's spending, taxing, commerce, necessary and proper, or none of the above and anything else, or the enforcement clauses of the 14th, 13th, 14th, 15th Amendment, 19th Amendment, then I'm for it.
I have a fair number of conservative listeners, and you just lost them all by saying Wickard was correct. But we'll leave that for another day. All right.
You didn't say it, but okay, fine. You can say Wickard wasn't correct and still maintain the broadness.
I think Wickard was 100% correct. The wheat industry was crucial to America. I don't want to go there. I think Wickard was correct. I'm just saying.
Yeah, fine. But you don't need any of those. You can find any rich hook to put a broad conception of federal power for the United States.
Agreed.
Which it became after the Civil War, not these United States, so that you can have congressional regulation of national matters.
One last question about the term, and then a final question about your new organization. At the end of the day, you've been suggesting in this podcast, and you are one of the most astute commentators I know, that the court is going to give a little, take a little, give a little, take a little, in style and in theory, but in substance, we're going to move far to the right. No, that's not your position?
Always.
That is your position.
Always. Yeah.
I think that's right. And I want so again, they're going to talk the talk of moderation, but in fact, they're going to move the law very far to the right. That is, I think, the single best description of the Roberts Court, really since its inception. When Kennedy was there, it wasn't the Roberts Court, it was the Kennedy Court. So there's only so much John Roberts could do. But that is what he's always wanted to do. Move the court slowly far to the right. Fair?
And well, yes and no. Move fast when it's a priority.
Yes.
So again, on abortion, on voting rights, on guns, on campaign finance laws, on everything that was a big deal for people who came up in the law in the 60s, 70s, 80s, 90s. Move fast on those. Effectuate the counter-revolution. Roberts was slower on abortion because he knew the political capital that would require he wanted to knock it out in 2 steps instead of 1 step.
Right.
And said, screw you. And now they're reaping the whirlwind, if you will, to use Kavanaugh's words that were then appropriated by Schumer. Okay. But, Roberts' whole project, and I think he has Kavanaugh and Barrett, not on everything, but to an extent in some ways, at least post the counter-revolution, is how to move forward in ways that can chart a new path, a new right-wing path, without being as conspicuously disruptive as the Fifth Circuit has been doing and as the Trump trial court judges have been doing. That's the project, because there's things where you're going to have the intra-conservative, the social media moderation cases before they.
Sure. We haven't talked. I'm sorry, we didn't even talk about the Twitter, Facebook cases out of Texas and Florida that are huge.
Okay, that's another cleanup on Fifth Circuit stuff, right?
Yeah.
That presents 2 paradigmatic issues that, do you stick with conservative ideology or Republican reactionary politics, right? Do you say the First Amendment doesn't apply to private actors, or do you say that the state power, we're going to use state power to make a private actor say what we want to say, consistent with our politics?
Yeah,
right. That's the current clash on the Fifth Circuit among the more normie Republican Bush judges and the Trump and the Trump judges, and some more extreme Bush judges there too. And that's a clash between the Republican majority on the 11th Circuit and the Republican majority that prevailed in the Fifth Circuit. Right, 2 competing priorities of the Republican judges.
Yep.
Whereas you have with qualified immunity, you have what's an ideological division among the Federalist Society's libertarian wing, which, I mean, sure, they exist, and the law and order wing. And that's a Kavanaugh versus Gorsuch thing. And you see that playing out within the Supreme Court and below as well. And those are the paths that they're going to figure out moving forward. Because once they sweep away all the things that were on the menu, that they got into the law, became lawyers to attack and get rid of. Once those things are cleared away, and they're almost done, then I think the only thing left is Chevron, which actually is more of a late blooming thing, and overturning what remains of Buckley and campaign contribution limits.
Yep.
The counter-revolution is done. Then it becomes what happens after that. What's the shape of things? Do you want to ban all private preferences, all preferences for race in private actors and banks? like which is what Stephen Miller's shop is trying to do, and some lower courts are going along with? Do you want to ban affirmative action in the service academies and not have a carve out, some artificial carve out that Roberts is floating? Yeah, like what do you do on the day after?
Right.
That's the question among the right wing.
It's great analysis, Mike.
That's what we have to keep our eye on moving forward. And this court right now is trying to hew carefully so as not to lurch so far on the things that go beyond the counter-revolution.
So I think Mike's analysis that he just put forward is spot on, accurate, and I want to make two observations about it. I'm being selfish. This is about me. The first observation is notice how little law played into Mike's predictions, because law doesn't matter. I don't know how, as Mike said earlier, I can scream down in this podcast and in my books.
This law. Law is power.
No. What I mean by that is constitutional interpretation doesn't matter. There's nothing that you mentioned. Right. It's not a good.
But it never did.
Well, that's my second point. So wait, hold on. Let me finish this. My second point is, I abhor the Roberts Court's politics, as I think Mike probably does to a great degree too. But neither of us can deny, and I don't think you will, that wherever the court is politically is what the court does. So when the Warren Court was to the left of the American center, it did leftist type things. That's very rare. Usually the court is moderately center left or moderately center right, depending on who's on the court. More often it is right, but it doesn't matter. My only point is, if we had 9 Kennedys, Blackmans, and Souters, we'd have a moderate court. If we had 9 Kagans and Sotomayors, we'd have a real liberal court. If we had 9 Titos and Thomas, we'd have a real conservative court. It doesn't matter. The point is, what you just described so beautifully, the battle between the Trumpians and kind of the Fifth Circuit James Hoeing wing of the Republican Party and the Roberts Old Guard 1990s Bush Republican Party is a real conflict. And that is what is deciding these things. Not text, not history, not precedent, not law. Thank you for letting me vent that way. All right, we got to end this. So, Mike, you're working for an organization called the Senior Court Accountability with Alex Aronson, who used to work for Sheldon Whitehouse. How did you get involved with this company, with this corporation, this nonprofit? What are you trying to do? And what are your 2 most important things? Like if you could snap your fingers and get 2 things, what would they be?
We're trying to show how this court has been captured by right-wing interests that have no interest in our democracy or want to preserve their power through the judiciary. And we show that through where the money's gone, through who's funded this ecosystem. It's been largely a Leonard Leo project for the last couple decades. The Koch brothers were a large part of the anti-regulatory regime, but that's been almost subsumed by the $1 billion+ that Leo has amassed in order to secure right-wing judges, so then to make and break policy that they want and don't want, that can't be effectuated through democratic means. And our job is both at Court Accountability, is to expose that, and also to allow to get the public to and policymakers, academics, lawmakers, to understand that this is what's at stake. That nothing short of our democracy and our ability to self-determine and self-govern is at stake here.
Do you think that the need for this organization? So there's 2 things. One is what they're actually fighting to do, which I find reprehensible and you find reprehensible, which is basically destroy American democracy and replace it with a Christian theological state of some kind. Maybe Judeo-Christian. I'm not even sure about that anymore.
We need Judeo out of this.
Yes, I agree. Yeah, I agree.
Thank you.
Okay. I mean, they wouldn't, but fair. But second, Mike, so I guess...
The co-optation.
Is that what makes this different? In other words, if you and I were having this, I mentioned this so many times on this podcast with progressive commentators and law professors. If you and I were our same politics in 1935, we would be devastated. We would be like, this court is ending this country. Like we would think what Roosevelt eventually said, which is we have to save the Constitution from the court. We got to save the country from the court, because they were getting in the way of him dealing with what he deemed to be, and we all thought was an emergency. If we would be just as mad then. Conservatives were just as mad in 1975 about Roe and Miranda and all that stuff. Is this the same old fights? And Dred Scott, right? Or for that matter, Lochner plus 200, all that stuff. Is this different because of no Supreme Court has been such a dire threat to our actual democracy as this one? Because if you believe abortion is murder, and we can't say people are wrong who believe that, if you believe abortion is murder, then Roe is the worst case ever. It authorized the murder of millions of babies. I don't believe that. You don't believe that. But so is that what I want to end this podcast on this note. Is that the difference?
So the way I see this court's and the right-wing legal movement's anti-democratic turn after talking so long about judicial restraint, not only is that judicial restraint was a canard, and it was just that was relative to the context of the moment. But I see the movement as almost like Gollum and the ring, Smigel in the ring.
You better explain that for the non-nerdy audience. Go ahead.
Yeah. Well, I've only seen the movies. I don't know. I've never read the Lord of the Ring books.
Okay,
but
they're great.
There's a true argument to be made that Roe, in knocking down a vast majority of the state's abortion regulations, was anti-democratic. Now, there's an argument made that Griswold was actually quite democratic because the people of Connecticut actually wanted the Comstock law there repealed, but the majorities, the Democratic leader and the majority in the Connecticut legislature was captured by the Catholic Church, and the Catholic Church did not want the repeal of Comstock laws, the contraception ban. So there's an argument made that Griswold was a pro-democracy decision, but Roe, the whole idea of restraint came from this idea that they were taking they were usurping the people's will and American democracy. But over the course of 50 years, in this dogged pursuit of overturning Roe and failing at every turn, having the ring just slip right out of their hands each turn, like what became part of the right-wing movement's objectives just start expanding. And when you think that the other side, who's taking away the ring from you, is committing a baby holocaust, right? That's the language. That they no longer have any moral right to rule. That means Democrats who back Roe versus Wade themselves are morally bankrupt and must be and have no right to rule this country, even if majorities back them. And we're at this moment now where you have this movement that, at least by its own profession, you can debate whether this is actually at bottom the case, was for restraint, was for getting courts out of the way, have turned and now want courts to control because they probably since 2000. Overturning Roe no longer could be seen to command a popular majority. Maybe you can argue Reagan came to power, George H. Bush was able to get elected because there were still popular majorities for thinking Roe was bad,
right,
or was constitutional law,
right.
But there's no question now that the majority of the American public believe in reproductive rights. There's no question. So what do you do when you no longer can talk about use democracy, use the will of the people, to support what is ultimately your constitutional and political agenda? You have to turn against against democracy.
Yeah, that's great.
To maintain what you want. And when every policy that if the other side, believes in this thing you think is a moral abomination, that means everything is tainted that they want, which means everything that Democrats believe for policy wise. And I'm not saying this as a Democrat or as a liberal. I'm not saying that. I'm saying this as an observer.
Yeah.
But when everything that the other side, which is morally abhorrent, what they want and the popular will wants, flows from this morally bankrupt route, then they must be un-American. They must be vanquished at all costs, and we will overturn democracy and destroy our democracy in order to restore what we think is the proper moral value in this country. Yeah. And that affects everything. It just metastasizes to every policy option. That's why you have these courts serving as the main policy-making and breaking body in this country.
It is amazing. It's a great point, Mike. It is amazing that in the journey to overturn Roe, the court takes away power from the states in virtually every other area of law, including gun regulation, takes away power from the federal government in terms of commercial regulation. I mean, in the name of judicial restraint, it seems like judicial restraint for the Roberts Court is a one-time only concept. It applies to abortion and maybe redistricting.
During the Obama era, I think the right-wing legal movement's position flipped to Democrats are unconstitutional and illegal.
Yeah, I agree. All right.
No, I'm really.
No,
and you see that most clearly now with Alito's jurisprudence.
Yeah, I agree. I agree. All right, Mike, we got to go. This has been way too long as it is. It's been so great talking to you. We are friends from way back, and it's been a long time. So I'm really glad we get able to do this. I want people to follow you, and I want people to follow this organization. First of all, Mike's on Twitter, and I assume Facebook as well, but on Twitter. He's a senior advisor at Court Accountability, which is a spinoff kind of from a Senator White House type of project. If you care about the right-wing capture of the courts, not just the Supreme Court, the courts, this organization is one you should pay attention to, maybe contribute to if you want. I'm going to plug it that way. Mike, thank you so much for being here. It's been great.
Yeah, my pleasure. Can I say one more thing?
Yes.
Our organization, myself personally, believe in democracy wherever it may lead, and having the courts get out of the way.
Me too.
So judicial activism for overturning Shelby County, Citizens United, Brnovich, the South Carolina case just happened. All the things that have served to constrict as opposed and suppress our democracy and to distort our democracy, those got to go.
Yep.
And then let the people decide where we want to go. But no more holding back of our political pendulum for your own side. Have faith and confidence that it'll swing, and when it swings too far, it'll swing back, etc. Right now, we of course are against that.
Excellent.
And they're against that because they want to preserve their power, and they have a whole apparatus, well-funded apparatus, holding that pendulum back for them and with them. And that's the battle here. It's not to constitutionalize progressive policy preferences.
No, I understand. And that's why, right, and that's why I've been asked like 20 times to talk about should liberals use originalism. No, liberals should use deference. That's what,
and democracy.
Yeah.
And democracy. That should be the principle.
Hey, how's that for a book? Deference and Democracy. Maybe I'll go out with that title. Mike, thanks for being here. I really enjoyed it. Thanks so much.
All right, Eric.
Okay.